Thank you, everybody, for joining us in what is the first of two webinars dealing with recent developments in the proceeds of crime arena. Today's webinar deals with the interplay between confiscation orders and family proceedings, and we will consider the different bases upon which proceedings are conducted and how an order in one set of proceedings might affect proceedings in the other forum. For those of you who don't know me, my name is Gary Pons, and I regularly deal with the enforcement of confiscation orders, and in particular with applications to appoint receivers. I have conducted financial remedies proceedings which are connected to confiscation orders, both on behalf of the CPS and on the applicant for financial remedies. Joining me is Sarah Wood, who's a specialist in both family law and in confiscation, making her one of a few practitioners who's perfectly placed to deal with the interplay of the two areas. So let me begin, if I may, by dealing with some of the relevant issues within confiscation proceedings. If I can have the next slide, please, Tess. Thank you very much. So I'm confident that most of you who are listening to this webinar know that confiscation proceedings follow on from a criminal conviction. They form part of the sentencing process. Confiscation orders are value-based orders, requiring the court to place a value upon two things. The first, the amount that has been obtained by the defendant in connection with his criminal conduct, and the second, the amount of the defendant's free property, together with the total value of all the tainted gifts that have been made by a defendant. That allows the court to make an order requiring the defendant to pay a sum of money to the court. The assessment and valuation of a defendant's free property and/or any tainted gift often includes the interest in the matrimonial home or in other jointly owned assets. That raises the questions of these partners' ability to argue that the confiscation order should not include the valuation of property that belongs to him or her. Next slide, please. That's where Section 10A of the Proceeds of Crime Act, POCA, comes into play. Section 10A is the mechanism which allows a third party to intervene in confiscation proceedings in limited and defined circumstances. It specifically applies when the court is making the confiscation order and not when it is varying the confiscation order. And so for that reason, Section 10A does not apply to revisiting that occur either under Section 22 or under Section 23 of POCA. The reason why is because in those circumstances, the court is varying and not making a confiscation order. The other requirements that are needed before the court can consider making a determination is firstly, that property must be held by the defendant, and secondly, that there is a third party who holds or may hold an interest in that property. Once those two things have been satisfied, then the court may exercise its discretion to determine the extent to which a defendant, to determine the extent of a defendant's interest in the property at the time of the confiscation order. The extent of the defendant's interest in property means its proportion to the overall value of the property of itself. Can I have the next slide, please? Section 10A permits third parties to participate in the confiscation hearing in order to argue that their assets should not be considered part of a defendant's available amount. It's designed to ensure that third parties participate either at confiscation stage or they wait until the enforcement stage, but not both, with the exception that's set out in this slide that's contained within Section 51(8)(b) of POCA. Next slide, please. That was the point that was made in the case of Hilton. Hilton was a Northern Ireland case that was dealt with in the Supreme Court in relation to the equivalent of Section 10A, which is Section 160A. The point that was made is that the purpose of Section 10A is to streamline the system, to combine the confiscation and enforcement stages in simple cases where there's unlikely to be any issue about how the confiscation order should be enforced. The court has a discretion to make a determination under Section 10A That means it doesn't have to. And so if it decides not to make a determination, that does not affect the validity of the confiscation order. The confiscation order remains valid. The reason behind that is because the third party still has an ability to assert their proprietary interests at the enforcement stage of proceedings. Next slide, please. In the case of Fort, the Court of Appeal considered precisely what it was that the Supreme Court meant by simple cases. It reiterated the point that Section 10A is designed to allow a third party to intervene either at confiscation or enforcement, but not both. And then it said if the real issue in confiscation is the third party's case, then it may be convenient, even if it is a significant and not simple issue, to deal with it then. In other words, expanding the extent of the court's discretion. It then went on to deal with procedural issues, noting that in relation to Section 10A, there's no strict procedure that governs the way in which the third party participates. But the court must ensure that the procedure that it adopts allows the hearing to be fair. In other words, it gives the third party the opportunity to participate in a way that is fair. Because of the nature of what is being argued, in other words, that the third party is arguing that they have proprietary interest in relation to the items that the court is considering in relation to the defendant's available amount, the third party is in the same position as any litigant whose ownership of property is an issue before the court. That means that the burden of proof is on the prosecution, the standard is the civil standard, and when it comes to the Section 10A determination, the court should make sure that that is dealt with separately from the way in which a defendant's available amount is fixed. They are separate exercises. Next slide, please. Dealing with the particular circumstances of Fort was a case that concerned the matrimonial home. In that particular case, it was registered in the wife's sole name, and unsurprisingly, she asserted that she was the sole beneficial owner. The husband and the wife had divorced, but there was no order for financial relief in the matrimonial proceedings. The Court of Appeal, when dealing with the case, said that where the property was the matrimonial home, that fact in and of itself is a highly relevant factor in determining beneficial ownership. If you like, a lean towards the fact that it's the matrimonial home will tend to suggest that beneficial ownership will be joint. The court said that any Crown Court dealing with this issue is entitled to look at the evidence and draw such inferences that they see fit in order to determine whether in fact the beneficial interest should follow the legal title. That, in my view, contrasts rather starkly with what Lady Hale said in her judgment at paragraph 66 of the case of Stack and Dowden. She said, I know of no case in which a sole legal owner, there being no declaration of trust, has been held to hold the property on a beneficial joint tenancy. That, if you think about it, is a good example of the different approaches that each respective court will take to a similar issue. The evidence that a Crown Court can consider includes sham divorce proceedings and the use of property for a joint purpose. It's not solely focused on the use of monies to purchase property. Can I have the next slide, please? In terms of the relevant case law in respect of determining parties' interests in property, the well-known cases of Stack and Dowden and Jones and Kerner still provide much of the guidance. The starting point is that there's a presumption that equity follows the law and that the beneficial ownership in the property is the same as the legal ownership. The burden of proof will be on any party seeking to rebut that presumption. In the absence of an express declaration of trust, the way in which that is considered is it's to be deduced objectively from their conduct. So what is being deduced objectively is the intention of the parties. How did the parties intend that their respective beneficial interests would be held? If the court is unable to determine, which is often the case, how the parties had agreed that their beneficial interests will be held, then the task of the court is to ascertain their actual intention, to look at what the court considers is fair, having regard to the whole course of each party's dealings in relation to the property. So that deals with disputes about ownership. But what about where there are no disputes of ownership? You would think, wouldn't you, that they're an easier case to resolve. But the next slide, the case of Bevan, tells us that that's not always the case. In the case of Bevan, there was no dispute that the beneficial ownership of the matrimonial home was held between the defendant and his wife in equal share. The Crown agreed, the defendant agreed, as did his wife. But in the case of Bevan, what had occurred was that the mortgage had been redeemed, albeit only in part, by the use of £140,000 that had been derived from criminality. They were, put simply, the proceeds of these offending. What the court decided, upon an argument presented to it by the prosecution, was that the wife was only entitled to half the equity in the home after the £140,000 was deducted. The basis of that decision was that it would be unfair and against public policy to permit the wife to enjoy the fruits of her husband's criminality. Although there's a certain logic to that approach, the difficulty is that there's no statutory basis for it. What the Court of Appeal did was they rejected it and specifically observed that it's contrary to the decision in Gibson versus RCPO. What the prosecution did not argue in the case of Bevan was that the wife's interest in the matrimonial home was a tainted gift, which almost certainly would have achieved what they were seeking to achieve, albeit by a different and arguably permissible route. Next slide, please. So having dealt with the case of Bevan, what flows from that is the case of Gibson, an RCPO, which is another case, an earlier case, dealing with a wife's knowledge of the tainted funds. This was a case where the husband and the wife purchased the matrimonial home in joint names. The husband had been convicted of importing cocaine. The confiscation order was made under the Drug Trafficking Act, and the basis of the confiscation order was an assessment that the defendant's realisable property included the entire beneficial interest in the matrimonial home. The prosecution applied to appoint a receiver, and because this was under the Drug Trafficking Act, that application was dealt with in the High Court. The wife applied and was permitted to join the proceedings. But both the prosecution and the court accepted that the husband and the wife were joint beneficial owners. However, what the court then decided was that tainted money had been used to fund the wife's interests, and the wife had knowledge. It was not a gift, the court decided, because the wife had given consideration by looking after the home and by raising the children. What they said, though, was that public policy, this is the High Court, was against the wife having an interest in tainted funds, and so it reduced her interest to a quarter of what she argued, which was 12.5%. She appealed. The Court of Appeal said that the High Court decision was wrong. In particular, it distinguished between matrimonial proceedings for a property adjustment order, which related to some of the cases that Sarah will take you through, cases that were presented before the Court of Appeal in the case of Gibson. And the question here, the case was not about what or how matrimonial property should be divided. It was not about an adjustment of what each party owned. Here the question was a simple one. What is it the wife owns? Once everyone had agreed that the effect of the presumption of joint ownership was that the wife owned 50%, well then it was inevitable that the receiver would only be appointed over the 50% that related to the husbands. In relation to Gibson, the reality is it's extremely unlikely that Gibson would be decided in precisely the same way now. That's because of the case of Hayes, which we will come to shortly. Next slide, please. Both Hayes and Bevan raise the question of gift, and the reality is that the gifts need to be considered carefully in relation to many of these cases. Section 10A, however, doesn't apply to cases of gifts because Section 10A, as I stated earlier, only applies where the defendant holds property which is likely to be used to pay the confiscation order. If there's been a gift, of course, he no longer holds the property because it's now held by the recipient of the gift. Next slide, please. A gift itself is not defined in POCA, but you'll see that in the case of Miles versus Lightman, modified by Mrs. Justice Jefford in the case of Samaya, the way that a gift is defined is that there must be a transfer of both the legal and beneficial interest in the property. That transfer must be voluntary and gratuitous, so no consideration. The donor must intend that the gift will not be returned to him, and the donee must accept the gift. Next slide, please. So that's the definition of what a gift is. In order to consider the question of whether the gift is a tainted one, there's a statutory test that's set out in sections 75 and 76 of the Proceeds of Crime Act. The statutory test of what is tainted focuses on the time that the gift is made, but does, as you'll see there, allow for situations where the gift is of the proceeds of crime. In other words, if you like, there's a presumption that if the gift is made, for example, where the defendant has a criminal lifestyle, at any time after the 6-year period, the court will treat that as if it is tainted, even if it's a gift of property that has not been obtained by or in connection with criminal conduct. Next slide, please. So dealing with the case of Hayes and the way in which it would change the approach or the decision in Gibson, Hayes, a case that was dealt with in the Court of Appeal in 2018, the decision included the fact that a gift can include the beneficial interest in the matrimonial home. This was a case where the property was purchased just with the defendant's funds, but it was conveyed into the joint names of both the defendant and his wife. And so the prosecution argued that it was a gift. In return, as was argued by Mrs. Gibson, the defendant argued that the familial service provided by the wife was sufficient consideration for the purposes of Section 78. The Court of Appeal observed that the Proceeds of Crime Act doesn't define gift, and it doesn't define consideration, but confiscation orders are value-based orders. And so it follows that consideration must have a value, and that value must be capable of being assessed in monetary terms. And that's set out in paragraph 58 of the judgment. Furthermore, the consideration must actually be related to the gift that is given. And of course, the provision of familial services is rarely connected specifically to the gift that has been given. The donee's knowledge of the criminal source of the gifts is utterly irrelevant. And you'll see in a moment when Sarah deals with her slides that in family proceedings, the contrast is the position, that the donee's knowledge, wife's knowledge of the criminal source of the gifts is particularly relevant. The familial services provided by the wife were incapable of monetary assessment, and the decision in Hayes was followed in the case of Cracknell. So that is a summary of how third-party issues, tainted gifts, and the position of the wife or husband are dealt with in confiscation proceedings. Can I now turn over to Sarah so that she can deal with the position in family?
Thanks, Garrett. Yeah, I'm going to deal with matters looking at it through the other end of the spectrum, and looking at matters if you have a couple who are divorcing in which one of the parties has been convicted of a criminal offence and there are confiscation proceedings running alongside the family proceedings. Next slide, please, Tess. Gary's just taken us through helpfully the Section 10A provisions and the way in which it all works, and looking particularly at how the court will determine a third party's interest in relation to property held by the defendant in order to establish what effectively is the available amount for the court to then make the confiscation order in relation to. Section 10A, of course, is useful and can be used and should be used where you have a husband and wife who perhaps aren't divorcing and who want to make it perfectly plain to the court that the wife's interest effectively should be ring-fenced and not be considered as part of the interest held by the defendant in the property. Where it's perhaps not appropriate to use Section 10A, in fact, not might be, it's certainly in my view, is not appropriate to use 10A, it is where you have parties who are divorcing. And it may be argued, some people may try to argue, that in fact what the court should do under a Section 10A determination is try and work out how matrimonial property should be distributed following the breakdown of a marriage. Now, the reason why Section 10A should not be used for that is twofold. First of all, the right to apply for relief, that being the relief within the family proceedings, that doesn't amount to an interest within the definition of Section 84 of POCA. The second and perhaps more fundamental reason is the fact that the way in which a defendant's interest in property is determined under Section 10A is determined in a very different way to that in which is determined in the family court. That's because in the confiscation proceedings in the Crown Court, the court are looking to see who owns the legal interest and therefore who owns the beneficial interest. In the family court, the legal and beneficial interest is largely irrelevant. What the court looks to do is to work out what is the value of what's known as the marital pot. And it doesn't matter in whose name the property is owned. It doesn't matter in whose name the pension is held, who owns the cars, who owns the paintings. It all goes into one big pot for the court to then divide it in accordance with its discretion within Section 25 of the Matrimonial Causes Act. The family courts, of course, then have a number of mechanisms and means by which they can give effect to the order that is made. So, for example, it can make a property adjustment order whereby one party transfers their legal and beneficial interest in a property to the other party. It can make a pension sharing order, or it can make a lump sum order, effectively to redistribute the assets in accordance with, as I say, its finding pursuant to the Section 25 factors. Section 25 is the section within the 1973 Act that sets out the factors to which the court must have regard. The starting point in any financial remedy proceedings is that 50-50. So husband will get 50% of the assets and the wife will get 50%. The court will then look to Section 25 to see which of those factors are relevant to the particular case, to see if it may, within its discretion, move away from that starting point of 50% towards another order in favour of one of the parties. As you might and probably would expect, that the first consideration in relation to that aspect is the welfare of any child of the marriage. And it's not hard to see and envisage, for example, a circumstance where you have the wife who has the care of the child. She plainly needs housing. And so in those circumstances, the court may look to move it from 50% in order to ensure that her housing needs and the housing needs of the child are met. That's the first consideration. Then it will come on to consider such factors as the income and earning capacity of both parties, their financial needs, the standard of living enjoyed during the marriage, the age of the parties, the duration of the marriage, because pausing there, for example, if it has been a very short marriage, then the court may be more inclined to put the parties back in the position they were before the marriage, as opposed to a 50-50 split. Any mental or physical disabilities of the parties, their contributions, both financial and non-financial, during the course of the marriage, and conduct. Now, in terms of conduct, the test is whether or not the conduct is such that it would be inequitable for the court to ignore it. And in cases where you have criminal behaviour on the part of, let's say, the husband, it is possible to argue, and it can be argued, and it has been argued within case law, that that is conduct which is inequitable for the court to ignore. And that may be a reason to enable the court to use its discretion to move away from the 50-50 starting point. The final point to remember in relation to Section 10A, and having in mind that we're dealing with its limitations and the reasons why it should not enter into the arena of dividing up marital property following the breakdown of a marriage, is to have in mind that Section 10A cannot bind the family court. It can, of course, as Gary has already pointed out, it can bind, and it does bind, any future enforcement court dealing with applications for a receiver, but it cannot bind the family court, and the reason for that is perhaps obvious. That's because the way in which the property is divided in the marital proceedings is completely different to the way in which the interests are established in the confiscation proceedings. Next slide, please, Tess. So let's say you have, running alongside each other, proceedings in the Crown Court for a confiscation order against the defendant, and at the same time you have one party, let's say, or the wife, has issued divorce proceedings against the husband and is now at the stage of embarking upon financial remedies proceedings against the husband. The question that will inevitably arise is which set of proceedings takes priority. And it's not hard to see, as the case law has stressed, that there are competing public policies in this scenario, because on the one hand you have the interests of the state, who are seeking to recover the money that they are entitled to pursuant to POCA and under the confiscation regime, and on the other hand you have the interest of the spouse, who needs to be catered for pursuant to the Section 25 factors. The case law has stressed and repeatedly stresses that neither claim automatically takes priority, and that was established in the 2003 case of A. And it's important to emphasize that at this stage, back in 2003, under the previous legislation of the Criminal Justice Act and the Drug Trafficking Act, both claims could be heard by the same judge. So they could both be heard by a High Court judge who was sitting with both a family hat on and a criminal hat on. That is now different, obviously, under POCA, because the confiscation regime, including the applications for enforcement, are dealt purely within the Crown Court. And therefore, you have two very distinct sets of proceedings running alongside each other. But nevertheless, and importantly, this still is good law, that neither set of proceedings should take priority. That being said, there are, it seems to me, three main themes that emerge from the case law in terms of particularly the family courts having in mind whether or not they should exercise their discretion under Section 25, or whether in fact they should let the matter be dealt with either by the confiscation proceedings, or in fact whether or not they should make determinations within the family proceedings which effectively enable the funds which would otherwise be available for distribution to be ring-fenced and then available for the confiscation. And those three themes are these, and number one and number two tend to overlap and are often considered together. So firstly, the extent to which the assets for distribution are tainted. So did they derive from the criminality? The spouse who hasn't been convicted, what did they know about the criminality and the activity of the other spouse? And then thirdly, whether or not the proceedings are being used to circumvent the confiscation regime, which can also give rise to questions of whether or not there is in fact a sham divorce. Next slide, please, Tess. So dealing then with the case of A, one of the leading cases back in 2003, which Andrew Bird from Chambers was involved in. This was a case at one end of the spectrum, in the sense that the wife neither knew about the defendant's criminality, and nor was it established that in fact the assets derived from criminality. This was a case, as you can see, under the old legislation, so under the Drug Trafficking Act of 1994. A receiver had been appointed under Section 29 of that Act in relation to all of the husband's assets, save for his interest in the former matrimonial home that was jointly owned with the wife, and the surrender value of 2 life insurance policies which related to the mortgage on the property. HMRC, Customs and Excise, applied for a receiver to be appointed over the entirety of the house, the entirety of the interest of the house, and the husband's interest in the policies. And they applied that the receiver then be empowered to take possession of the house and sell it in order to realise the husband's interest in it. Again, as I said, because this is under the previous legislation, the judge heard both claims alongside each other. So he heard the family claim alongside the application for the receiver. And having heard that, he rejected the application on behalf of Customs and Excise for the reasons that I said at the outset. That was because it was found that none of the equity derived from the proceeds of drug trafficking, and the wife had no knowledge, and therefore he felt he was entitled to exercise a discretion within Section 25 and moved from the starting point of 50-50, ordering the house and the policies to be transferred to the wife. So say that's an example at one end of the spectrum. Turning then to the next slide, please, Tess. CPS against Richards. This is now a 2006 case, but we're still dealing with the old legislation under the Drug Trafficking Act. This was a case at the opposite end of the spectrum. In this case, the parties owned 4 properties, with the exception of 13% beneficial interest in one of those properties that was a gift from the wife's parents. It was established that the remainder derived from the proceeds of drug trafficking, and importantly, that the wife knew that that was the source of the funds. At first instance, the High Court, again, it being under the old legislation, exercised its discretion within Section 25 and made an order in favour of the wife. That was then overturned on appeal. And I've set out there on the slide, which you will get in due course, paragraph 26 of the judgment, which makes it clear and stresses what had been established in the case of A, which is that where the assets are tainted and subject to confiscation, they should ordinarily, as a matter of justice and public policy, not be distributed. The court did go on to say, and this is where the discretion aspect comes in within Section 25, that there may be circumstances in which the discretion can be exercised, but that's the starting point. If the assets are tainted and the wife knew, then they should not be distributed within the family proceedings. Moving on then to the next case. The case of Weber and Weber is an interesting case to read, because it perhaps demonstrates and is a good run through, or read through rather, of the overview of the way in which the previous legislation used to operate in comparison with POCA. The case of Weber was a case that was an application that was pursued under POCA. It also is a good summary of the main themes that derive from the case law. But it also is a good example of how things can go slightly wrong because people were relying upon the previous legislation and thought the same applied in relation to POCA. So in this case, the financial remedies had started in Basingstoke Family Court. They then got transferred to the High Court. At that stage, a consent order was agreed, but importantly, without the knowledge of the CPS. And that order was agreed on the basis that the matter should be dealt with by a judge sitting with both hats on, so both with a criminal knowledge and a family background. That order was overturned by the president of the family division. It was conceded in the confiscation proceedings that the wife's interest was not tainted and that she was entitled to 50% of the matrimonial home. And so on that basis, it was agreed that the family proceedings should take place first in order to enable the Crown Court to then subsequently be able to properly assess the husband's available amount. Moving on to the next slide, please, Tess. Stodgel and Stodgel is an interesting case in the sense that, having just said to you that taint and knowledge are the two main aspects which the family court, if they are asked to consider it, are the two main aspects that the court will consider. Stodgel and Stodgel slightly throws a spanner in the works in relation to that, because that establishes that it's not always necessary to prove both the taint of the asset or the knowledge on the part of the spouse in order for a confiscation order to take priority. In the case of Stodgel, the husband had been convicted of fraudulently evading income tax. The confiscation order was made in the sum of over £900,000, comprising both unpaid tax and penalties. Now, the wife had no knowledge of the husband's criminality, and notably, she had no proprietary interest in the properties, and that was the reason in particular that she had to commence financial remedy proceedings in order to obtain any interest in the properties, and that's why she asked the court in the family proceedings to exercise its discretion under Section 25. Within the family proceedings, the wife argued that those proceedings should be heard in advance of the husband applying the assets, having in mind, of course, they are in his sole name, before he had used those assets to satisfy the order. So effectively, she wanted her application to be heard first, before the husband had the opportunity to comply with the confiscation order. Now, the family court refused that application on behalf of the wife. The wife appealed, and leave to appeal was refused. Now, in refusing leave to appeal, the Court of Appeal found that the wife's lack of knowledge was insufficient, and nor was it critical that the properties had not been obtained from crime. What the Court of Appeal were concerned with was the fact that the asset base, so the asset base that was then to be distributed within the family proceedings, had only been accumulated due to non-payment of tax and penalties. And notably and in particular, the court found that it was the wife's concession that HMRC could have bankrupted the husband, that was fatal to the claim, because if HMRC had pursued bankruptcy proceedings at any stage before the point at which the wife made the application for financial remedies, then that bankruptcy would have effectively have trumped the financial remedies proceedings, and therefore there would have been nothing left in the pot for distribution. Stodgel and Stodgel is obviously a case on its own facts, given the nature of the underlying criminality, and you can see how it wouldn't occur if, for example, the assets had been derived from drug trafficking or effectively anything other than this particular offence. But where you have offences deriving from the evasion of income tax, in which HMRC are involved, it's important to bear in mind the facts in particular in relation to this case. Next slide, please, Tess. So those cases that we've just trotted through there, those are the headline cases in relation to how the family court, which is obviously what we're dealing with, how the family court should exercise its discretion. We're dealing with tainted assets and a wife who may or may not know of the underlying criminality. The other aspect that the family court must have regard to is the question of whether or not, in fact, the family proceedings are being used as a way of putting assets beyond the reach of the confiscation regime. And that was stated within, as I say, within paragraph 101 of the judgment of Lord Justice Wall within the case of A. It seems to me that on the face of it, this scenario can encompass a number of different factual situations, and it's not limited to the three that I've set out on this slide. It's not hard to see that there may be other situations where this may be of concern to the family court. But what the CPS if they intervene within the family proceedings, which we'll come on to look at in a moment, what they may seek to persuade the family court is that the divorce itself is a sham, and there may be evidence available, perhaps through social media or perhaps through payments from one party to another, which have continued beyond the point of the divorce. If they consider it to be a sham divorce, that they may seek to make that argument within the family proceedings. That's, again, at one end of the spectrum. The other end of the spectrum is where you have one party who deliberately doesn't ask the court to exercise Section 25 in their favour, or perhaps who deliberately doesn't engage with the family court process with a view to ensuring that the assets are distributed in favour of the innocent spouse. And perhaps it's not hard to understand why one party may seek to do that, because they may simply prefer that in the circumstances and the situation that they find themselves in, they would prefer that their spouse received the assets as opposed to the state or the police. But in those circumstances, what the CPS may seek to do perfectly legitimately is to ensure that there isn't effectively a sideswipe of the assets in favour of the other party, and may step into the shoes of the convicted party to ensure that Section 25 is still applied properly, even though ultimately the assets that are distributed, let's say, towards the convicted party, doesn't matter that they're going towards satisfying a confiscation order. What the court still has to be satisfied is that Section 25 has been operated and applied correctly. Next slide, please, Tess. So having looked at the main themes from the case law, the question obviously then arises is how do these apply in practice? But the first thing to try and establish, if possible, is which set of proceedings are going to be heard first. Now, inevitably, or I say inevitably, but it's more likely than not, that the CPS may seek to argue that the confiscation proceedings should be determined first. However, in that scenario, it may be possible to agree with the CPS if, for example, you are acting on behalf of a husband or a wife in the family proceedings. It may be possible to agree with the CPS that they won't apply to enforce the confiscation order until the family proceedings have concluded and until any necessary Section 23 application has been made. Because it's not hard to see in a straightforward case where, let's say, a property is held as joint legal owners of the matrimonial home. Within the confiscation proceedings, the court makes a finding that the defendant's available amount relates to his 50% of the property. If there are then family proceedings, if the wife is able to persuade the court that she is entitled under Section 25, that will then take away, let's say there's a property adjustment order in favour of the wife. It's not hard to see then how the defendant in that situation will need to return to the confiscation proceedings, return to the Crown Court and make an application under Section 23. Now, if, however, the family proceedings are to be determined first, then the CPS may apply to intervene in those proceedings to protect the assets. And it will do so, particularly if it suspects that any one of those things that we've just looked at from the case law is applicable to the particular case that is before the court. So if, for example, the CPS take the view that the matrimonial home has been purchased through tainted funds, or if it suspects that the wife had knowledge of that, then it may seek to intervene in the family proceedings in order to effectively take those assets out of the equation for distribution so that they can be used in the confiscation proceedings. Either way, it seems to me that it's important to be aware and alive to the detail of both sets of proceedings, which can, of course, be difficult. Coming back again to the fact that we're now dealing with POCA, you have two sets of proceedings, and inevitably you will have two sets of solicitors, the family solicitors and the criminal solicitors. And so there needs to be channels of communication between them to ensure that both sets of solicitors are aware of the detail of both sets of proceedings. The other thing, of course, to be alive to is that because they are two sets of proceedings, there are different rules that apply in relation to cross-disclosure between the proceedings. And if you want to use within the family proceedings documents that have been particularly, say, for example, the Section 16 statement that's been served within the confiscation proceedings, if you want to utilize that within the family proceedings, then you need either the permission of the Crown Court judge or the author of the report if that Section 16 has not been used in a public hearing. And that, of course, is Criminal Procedure Rule 33.8. By the same token, if you want to use documents that have been served within the family proceedings, if you want to use those in the criminal proceedings, you will need the permission of the family judge pursuant to the Family Procedure Rule 22.20. Next slide, please, Des. So if the CPS do decide that they want to intervene in the family proceedings for the reasons that I've just set out, because they have concerns about ensuring that the assets are kept available for the confiscation proceedings, the way in which they do that is by making an application that's in accordance with Part 18 of the Family Procedure Rules. That is a Form D11 that's supported by evidence. And in effect, that sets out in simple terms why it is that the prosecution say that they should be allowed to intervene within the family proceedings. The basis of that application is usually twofold. The most important one to have in mind is Section 58 of POCA, which states that if a restraint order is in existence, then before any order is made within the family proceedings, then the Crown Prosecution Service must be given the opportunity to be heard before either the proceedings continue or they're stayed. Pausing there, it's important perhaps to bear in mind that if there is a restraint order in existence, if a husband or wife are seeking to try and arrange and agree a consent order, and there is in place a restraint order, then they must notify the CPS that is their intention. Otherwise, that consent order could be undone by virtue of the fact that the CPS had not been informed within the provisions of POCA Section 58. The other basis of the application is the Family Procedure Rule 9.26b. In summary, that effectively says that where there is a party who may have an interest or there is an issue between a third party, that's the rule that effectively allows and is the gateway by which that third party may intervene within the family proceedings. Next slide, please, Tess. So you're at the stage now where the CPS have been given permission to intervene. For argument's sake, let's say that they were put on notice by one of the parties to the proceedings, and therefore you're at the first appointment stage, and the court is dealing with directions. If the CPS at that stage are likely to be considering whether or not a preliminary hearing is going to be necessary in due course further down the line to determine the questions that we've looked at. So whether or not the assets are tainted, whether or not the wife knew, or whether or not the family proceedings are being used to deliberately put the assets beyond the reach of the confiscation regime. But in order to determine whether or not that preliminary hearing is going to be necessary, what needs to happen is that there needs to be service of evidence in order for the parties to consider where the case is going. And the directions that should be made, and ideally made at the first appointment, are those that are set out in the case of W and H. They are fourfold. First one is perhaps an obvious one, which is that the CPS must be provided with all the papers in the proceedings. The second one is that the applicants is to serve a statement setting out their entitlement not only to the beneficial interest in the property, but also the scope of any financial remedy claim. And again, that's coming back to the Section 25 factors. The respondent is then to respond, and then notably and significantly, the CPS are then to serve a statement setting out what is its case is. And it should set out whether or not it accepts the applicant's claim. And again, coming back to the case law that we've looked at, setting out whether or not, in its view, by reference, of course, to evidence, whether or not the assets are tainted, and whether or not the applicant knew of the underlying criminality. That statement, of course, could also include questions in relation to any sham divorce, and whether or not, in the view of the CPS, again supported by evidence, the parties are simply trying to circumvent the confiscation order. That is, as I say, a quick run through of looking at both aspects, looking at both regimes through different lenses. So looking at the family proceedings, what happens within those proceedings if there are concerns on behalf of the CPS as to taint, and looking at it from the other side of the spectrum within Section 10A in relation to the defendant's interest in the property, where you have a third-party issue being, a third-party claim being asserted. In terms of any questions, whilst I've been speaking, I don't know if we've had any questions come in, Gary or Tess.
I'll take myself off mute for the moment, but before we get to questions, there's one thing that I'd like to kind of pull together and just ask you about, Sarah, if I may. Obviously, the one thing that's fairly thematic about what we've just dealt with is that the different sets of proceedings plainly have different issues, and they've got different considerations. But looking at the interplay, and in particular how the decision in one court might be regarded in the other court, it seems to me, thinking about it, that it's much more likely that a decision made by the family court about the assets and how they'll be distributed, it's more likely that that will be decisive in the Crown Court, particularly if it's made before the confiscation order, than the other way around. So a decision by the Crown Court in respect of who beneficially owns the matrimonial home, that's much less likely to be determinative because of the different considerations of the family court. What do you think?
I agree entirely, Gary. And you've effectively, in a nutshell, set out what this seminar is all about, and it's the different tests that are applied in the two different sets of proceedings, and that's why it can become so difficult in terms of trying to advise clients as to which set of proceedings should go first. Because there are different tests and different considerations applied. But I agree entirely that it's more likely that a family court could simply disregard any finding that's been made under Section 10A or any confiscation order, because there are different factors at play.
And in terms of which proceedings should go first, firstly, you're not always going to have a choice about it.
No, yeah, agreed.
For reasons that are particularly obvious. Secondly, there's no kind of real general rule in relation to strategy. It's a case-by-case analysis that depends upon the particular facts in the case that you're dealing with. Would that be fair?
Yeah, absolutely. No, there are clear-cut cases that we've looked at where the assets are clearly tainted and the wife clearly knew. Even if the family proceedings go first in that situation, it's likely that the assets will then be taken out of the equation in terms of any distribution under Section 25. The more problematic ones are where there is a little bit more grey in terms of whether or not the assets are tainted and whether or not the wife knew. And then there are real issues and real questions as to which set of proceedings goes first and how the family court should deal with that.
Okay, excellent. Well, that's all from me. I don't know, Tess, if you can join now, if there are any questions that either you have, or if there's anyone in the audience that wants to ask a question, either by way of the chat or just asking you to unmute them. We've got a couple of minutes left to finish off.
Hi, Gary. Hi, Sarah. Thanks for that. There were a couple of people that raised their hands, but I haven't had any questions coming through. I know we had one that came through on email. I don't know if you want to generally deal with some aspects of that quickly.
I think there were 3 parts to that email, and there's one dealing with costs that I think we can deal with within the short amount of time that's available to us. So if you could do me the favour, Tess, I don't have the precise nature of the question to hand. So if you're able to read that out, that would be quite helpful.
So in relation to the family court, if it rejects a claim by the CPS, can a costs order follow, bearing in mind they are not simply honest brokers? I think that was the thrust of it. And has the CPS has a financial interest in recovering as many assets as possible.
Let me deal with the first. Let me deal with part of that before I pass it over to Sarah. Well, obviously, when it comes to the CPS intervening, particularly if it's post-confiscation order, the reality of their role there is they're effectively acting in the shoes of the court, because the court, of course, is the payee, the recipient of the confiscation order. And so often what they are simply doing there is enforcing a confiscation order that's already been made by the Crown Court. And in doing so, they're really following the statutory aims and objectives that are plainly contained within the Proceeds of Crime Act. And that, I imagine, Sarah, is how they are typically dealt with. It certainly is in the cases that I've handled.
Yeah, I agree. In terms of the second limb of the question, Tess, in fact, maybe the first limb in relation to costs, the ordinary rule in family proceedings is different from the ordinary rule in civil proceedings, which is that each party bears its own costs, unless the litigation conduct on behalf of one party has been so unreasonable that the court should consider a adverse cost order against the other party. That being said, and that being the normal and the standard rule in proceedings between a husband and a wife, but where you have a party who intervenes, the normal cost rules don't always apply, and in fact the normal civil rules apply in terms of loser will pay the costs of the winning party. But again, that being said, the court will take into account the conduct of the party, and if it takes the view that the CPS have intervened properly, have complied with the rules of the court, the directions of the court, and considers that the application was made properly, then it's unlikely, it seems to me, that the CPS will have an adverse cost order made against it. Certainly in my experience, when I've intervened on behalf of the CPS, even where we haven't been successful in terms of what we were seeking, the court has taken the view that the application was nevertheless made reasonably, and no adverse cost order has been made against the CPS.
Okay, we're bang on 6:30. What do you think, Sarah, Tess? Time for one last question, or should we wrap it up there?
Perhaps you could deal with one very quickly, and then we'll wrap it up thereafter. And we can always email the participants following on from this.
Sure, I'll deal with Ashley's question if I can. So it's a question from Ashley Fairbrother, and I'll read it out so that everyone can consider it. The question is this: to what extent would you advise non-spouse third parties with weak claims to make a Section 10A application in POCA proceedings to avoid the risk of adverse cost orders if they lose? And to what extent would you advise them with strong claims to refrain from making a Section 10A application and assert their right in either property or receivership proceedings, so they can get their costs back, which may be considerable? I mean, my instinctive reaction to that is it's very, very difficult to deal with these kind of questions in the abstract, because a lot depends upon the precise detail. So the precise detail of the nature of the property, the precise detail of the nature of the property rights, how they're obtained, how much money that you're looking at. Certainly, I can't immediately think of why you'd want to go in receivership proceedings and not Section 10A. There may be reasons, but there's nothing that's immediately popping into my mind. For practical reasons, despite the cost order position, there may be a good reason why the third party would want to assert their interest in Section 10A proceedings and try and get it released and returned to them quicker rather. Those are my initial thoughts. Not always easy to give a considered answer, I think, off the top of your head. Sarah, I've given you a little bit more time. What do you think?
And I think on the whole, I agree with you, Gary, not least because there's no guarantee that there'll be receiver application.
Exactly, and even in those, although you may get your costs back, it's by no means guarantee. There is, after all, discretion.
Yeah.
Okay, sorry, Ashley, but that's I think the best that we can do off the top of our heads. So, Tess, Sarah, if that's all, I think we need to wrap it up there. Thank you all for attending. I hope that was of some help to all of you. Thank you very much.